Case number 17-2213, John Doe versus David Baum et al. Argument not to exceed 15 minutes per side. Ms. Gordon, you may proceed for the appellant.
Good morning, members of the panel. I would like to reserve 3 minutes for rebuttal. Members of the panel, I know you are very familiar with this issue. This circuit has been on the cutting edge recently of issuing pivotal opinions with regard to due process rights of students at public universities. The University of Michigan and the defendants in this case offer no hearing of any kind and no cross-examination of any.
Can I ask you something that's going to maybe take you off track a little bit?
Sure.
But I want to ask it early, but I don't want you to spend a lot of time on it because neither party seems to think it's a problem that I found it to be.
All right.
The district court incorporated on motion to dismiss the materials that had been offered in connection with the hearings on the injunction and such. He didn't convert the motion to dismiss into a motion for summary judgment. Yet I found the record much more amenable to a summary judgment analysis, although that's not something the appellate court would do sua sponte. But
I think it's an excellent point. I take your point. Nonetheless, I'm standing here in the posture set forth by the district court, but I certainly do agree that it does appear that factual inferences were made and facts were judged at the district court level, in large part because the materials attached.
I mean, it just doesn't. It's a misfit.
All right,
I'm dealing with it, but
okay, I understand. It does make sense. In any event, to continue, Your Honor.
Can I ask one follow-up to that? Because I agree with Judge Gibbons
Yes.
and everything she said, but both parties agreed to this weird posture, correct?
Well,
no one objected.
That is correct.
Okay.
Judge Thapar, I would say that is correct. All right. University of Michigan offers no hearing of any kind. It offers no cross-examination of any kind.
What about their argument that the investigator gave a hearing?
Okay, well, here is the process used by the investigator, Judge Thapar. There is exactly one interview. At the time my client was interviewed, the claimant had already been interviewed, but my client was not provided with any information that she gave. This court has been extremely clear in its decisions that a private interview all by itself is certainly not a hearing, and that is directly from Doe versus Cincinnati. There is no case in this circuit that has ever ruled or will rule that a private interview process where the appeals panel is the decision maker provides due process. And let's assume, for sake of moving this argument along, that the private interview was a hearing, which it clearly was not.
Yeah, I wouldn't concede that, but I guess if I were you, but I would ask a follow-up, which is their point that if you didn't object, and in fact, in your complaint, praised the process your client got from the investigator.
Sure. Here's why. My client prevailed. There was no deprivation of a property interest or a liberty interest, period, full stop.
So your point, just so I understand, and then I'll stop and let you argue, I'm sorry, is that the due process right kicks in when the deprivation kicks in.
Absolutely. I mean, if I had come before the court and made the argument that my client had no due process below, which he did not, but he had prevailed, there's no deprivation and there's no legal argument. It turned out that this investigator, who wrote a 42-page opinion, found that there was no possible way, given the credibility issues, that there was a preponderance of evidence that she could rely upon. Okay, horrible process. This is not my first case against the University of Michigan. It's really unlike any other case, any other university. It's nothing like Cincinnati, Flam, Cummins, Rochelle. No other school has this policy. In every other case, this
Can I ask you what the hearing must look like? You're asking for cross-examination in a hearing, which makes sense. What level of cross-examination?
All right, that's an excellent point. And let me just tell you, there was recently another case filed I have a recent opinion from Judge Tarnow in the U.S. District Court, Eastern District of Michigan. Another
With all due respect to Judge Tarnow, he's not what the law is in the circuit.
Oh, I agree completely. All I'm telling you
And we've spoken on this to some degree in other cases.
Yes. So, fair point, Judge Gibbons. All I wanted to tell you was that he, in fact, I'll let that go for now, but with regard to Judge Thapar's question, it's very, very clear here, Judge Thapar. I know you all have parsed the kind of questioning that should be allowed, and I understand why. You're concerned about Title VII, but I am here to tell the court today that Title VII is very different than due process. And this court must view this case through a due process lens.
So we understand all that. Still, what's the answer to the question? Whether Judge Tarnow says it or you say it, what is the answer? What cross-examination are you looking for? What level is necessary under the due process clause in this case?
All right, so Matthews versus Eldridge has a balancing test. The defendant in this case, Judge Thapar, has never offered an explanation ever as to why my client does not get the identical due process, full questioning allowed to every other student in the Statement of Student Rights and Responsibilities. Why my, and I'm holding up for the court the document, why my client is shuffled off to a separate, significantly deficient process called the Statement of a Student Misconduct.
So you're saying in every case with sexual misconduct, the university promises a certain process?
They promise it, they offer it, it's a full hearing, you get full questions.
Is just the affording of those procedural protections accord with due process?
Yes, and in fact, Judge Gibbons, this statement says in its preface, we are here to offer all of our students due process. And then they go on to describe the full hearing. Let me tell you this, if an African American student is attacked by 3 white male students, the attacker get to cross-examine the African American student. I fail to see the distinction as a person who has represented women my entire career in sexual harassment claims and in due process claims, why, if that student who was attacked, the African American student, must sit there and answer questions from his attackers, why an accuser in a sexual assault case cannot deal with the same questions. Judge Thapar, as a fallback, of course, I would go with the Doe versus Cincinnati ruling, and I would go with written questions.
Just so I'm clear, what you're asking for is the rights they afford every other student at the university.
And I think under Matthews versus Eldridge, that must be the case, because your opinions, your Judge Griffin's opinion and your opinion, Judge Thapar, in Cincinnati, I could see, obviously, you weighed, okay, what are we going to allow? And right there, this court said, we see the plaintiff is not asking for anything other than written questions. That was
right,
clear.
well, that's why I'm asking the question.
Of course, and I am asking for the identical same rights that every other student is given that I believe are required.
That sounds like a claim that's not really, and I can't remember exactly what your complaint alleges on this point, but that sounds like not a due process claim, but a claim that is some sort of failure on the part of the university to follow its own procedures. Now, how did you package that?
Yes, I didn't really argue that. We did say for various other reasons they failed to follow their own procedures in the sexual misconduct policy. But I'm not here to spend my time arguing that their failure to follow their own procedures is a due process violation, because the case law is mixed.
Their procedures can't define what due process is or isn't.
Exactly.
So it must be packaged some other way. And you just told me, I think, that it's not packaged any other way and that that's not your claim. So then isn't what Doe versus Cincinnati has to say about it a whole lot more pertinent than what the university promises or doesn't promise? I mean, I agree, you ought to follow your procedures and you ought to give what you promise, but
Well, my answer is this. This court has said that some form of cross-examination is required. And in Cincinnati, this court found that it would be circumscribed. And it was found for only one reason: the burden on the university. That is the entirety of the Sixth Circuit's position on why it would only be circumscribed.
Well, go ahead. I'm sorry.
And I can,
Well, it seems to me, I don't believe you made this argument, but I'm just about to make an argument for you. Shouldn't what you be saying be that the burden on the university cannot possibly be of any magnitude if this is what it affords in other cases?
yes, of course. And I also want to say, Judge Gibbons, that because this came up in Cincinnati, the Department of Education in 2017 has now taken the following position, because that was discussed previously. The standard of evaluating a claim of sexual misconduct should be consistent with the standard the school applies in other school student misconduct cases. It can appear to be an effort to tilt the playing field if it is anything else. So it is absolutely clear now in 2017 the Department of Education has acknowledged and recognized that it is improper to offer a different position. I have one other thing I must say before I sit down. I need you all to understand what happened to my client here. He was found not to have violated the policy even without due process. Then came the sham appeal, where it was a panel of 3 people who never laid eyes on a single witness and utterly flip-flopped the entirety of the OIE investigators' report, finding every single fact in a light most favorable to the to the female accuser. The report is laden with references to her high school history of drinking. She wasn't experienced with partying. They bent over backwards without any ability to assess credibility or demeanor of any witness. I also want to tell you, my client was never even given witness names. The fact finder, the investigator, had one interview with him, one with the complainant. Everybody else was interviewed by phone. This completely flies in the face of any fundamental fairness. And I have to say this: where are the stakes higher than a young person who is losing his education? My client will never be able to say he graduated from the University of Michigan Raw School of Business. He had 13 credit hours to go and a 3.94 GPA. And the sham process will be a part of the rest of his life story. I thought you went to the University of Michigan. Why didn't you graduate? From his employer, from his friends, from his future in-laws. We requested that the university allow him to complete those 13 credits remotely. He wouldn't set foot on campus. They absolutely said no. They've taken a punitive attitude towards many students. Title IX, members of the panel, does not allow for punishment. It does not allow for that. The only thing it says is that the harassment must stop. And I must say, with all due respect to the university, which I attended, as did my daughters, they have taken this too far. Their process flies in the face of everything that due process stands for, and they are dug in. And I reserve some time.
May it please the court. David DeBruin for the appellees. I want to start with responding to your question, Judge Gibbons, but first I'd like to respond to the closing argument you just heard. You talked about a sham process. You heard nothing about what plaintiff John Doe did that night, what was investigated at length by the investigator, what the appeals...
The investigator found that it was at equipoise at best, and if you look at the factual record that the investigator found versus what the appeals board did, she seems to be right. There seem to be some real problems in what they did.
And I want to address that, but I think it's important that the court consider the evidence, which I will review at length when you consider the equities in this case. But let me now step back and start with Judge Gibbons' questions, which I think is very important, which is the posture of this case. The posture of this case was entirely appropriate, Your Honor, for 2 reasons. First, it is black letter law that on a motion to dismiss, a court can consider the materials that are referenced in and relied upon in the complaint. And so in this case, Basically, the complaint referenced at length, quoted at length, the first adjudication, and that is what the OIE decision is.
So if they do that, do they have to view it in the light most favorable to the plaintiff?
Yes, I believe they do, Your Honor. But again, so the complaint references the decision, the initial decision, which was an adjudication by OIE, the Office of Institutional Equity. The complaint also referenced the appeals board decision, which reversed that initial decision.
So those things which were the bulk of what was presented in connection with the injunctive relief request would be considered in any event, and it sort of doesn't matter.
Well, and that's my second point, that these cases are very similar really to an Administrative Procedure Act case, where essentially a case is brought in federal court challenging a state agency determination. And that's basically what a disciplinary adjudication is. And so you're looking at the record that was decided as to whether that record reveals a procedural due process violation. And so in terms of the posture here, it is perfectly appropriate, again, based on the materials referenced in the
I
complaint.
didn't say it was inappropriate. I suggested that it made the analytical process a bit more difficult because the materials we have seem to fit more naturally within a summary judgment context.
Well, and that could be true. In, again, the APA context, courts have recognized that motions to dismiss summary judgment are essentially the same thing. But what is critical is that what Judge Lawson reviewed was the initial adjudication of OIE, the appeals board decision, which he looked at great length over a very extensive opinion, and that was appropriate on a motion to dismiss. What I think is critical in this case is to consider separately the two phases of the adjudications in this case. There was an initial adjudication by OIE that resulted in a decision. And yes, it was a decision that was favorable to the accused, the respondent in this case. But you have to look at this court's precedents, evaluating the process in the context of that initial adjudication.
The appeals board made credibility determinations without affording the plaintiff in this case any opportunity to have a hearing or cross-examine witnesses. And they took away, essentially, his education.
Your Honor, the stakes are high, again, for both sides.
So why not give a hearing like you do in every other case?
Your Honor, I submit, if I can just answer that question, and then I'll come back to you, Judge Gibbons. The adjudicatory process that was done by OIE here was, in many respects, better, more detailed.
No, it wasn't.
And let me explain
Wait a minute. Answer my question, then say what you want. The university never gave him a hearing and cross-examination like they do in every other case, correct?
There was a hearing by the hearing officer, Officer Klein.
So you're saying an interview is a hearing?
It's not the interview. It is the full conduct of interviewing 23
Well,
different
making
witnesses.
findings based on interviews is not what I think of when I think of a hearing.
Your Honor, it is not a traditional hearing, but there is an extensive
And there wasn't
development of
any
a
more
record.
process provided at the appeals level. In fact, there was arguably less because the appeals panel, which didn't need, sitting more removed, didn't even have the opportunity or inclination to interview witnesses, stepped back and made different findings. So now he's got less process than he had gotten at the end of the investigatory proceeding.
First of all, the hearing officer, Officer Klein, who rendered the decision, she made a very detailed
But she didn't have a problem of anything when she rendered the decision. The problem is the appeals board deprived.
Your Honor, that could happen after a full traditional hearing. You could have a full traditional hearing where everyone comes together at one place, which is less thorough, because in that context, unlike the statement that Ms. Gordon
It's
relies
not
on.
less thorough. That means you disregard everything courts have ever said, including the United States Supreme Court, about cross-examination.
Your Honor, I urge you to look at this court's decision in Newsom and consider Cincinnati and Newsom together. Newsom is cited multiple times in Cincinnati. Newsom is cited by this court's decision in Cummins. Newsom holds cross-examination is not required.
But here, in Cincinnati, you said when credibility is at issue, cross-examination is required. And if you look at the appeals decision, They reference credibility multiple times, and in fact, if I show you the two records, the investigative report where the sorority sister said, well, I wasn't sure if she was drinking, I wasn't sure about this, I wasn't sure how drunk she was, and then you look at the appeals board, they say, oh, 2 witnesses, and there's only 2 confirmed. And there's no evidence of that.
What's critical, the issue before the appeals board was not consent. Consent often turns upon the credibility of the 2 individuals who are present alone when the sexual act occurs. The issue the appeals board considered was incapacitation.
Well, and that
they
makes
decided
it
based on
not-
objective evidence.
If you can just stop while I ask this question, that, in my opinion, makes it even more problematic for the appeals court, because when you look at the things in this record and you're taking, again, in the light most favorable to the plaintiff, there's evidence about the plaintiff recalling, I mean, not the woman recalling a good bit of what happened. She's able to recount what happened at critical points. She texted clearly immediately afterward and throughout the night. I mean, none of that. There's a factual dispute about how much she had to drink. I mean, some of the evidence of didn't appear intoxicated doesn't jive with the other statements about what she had to drink. I mean, the whole thing is just replete.
Your Honor, what the appeals...
If I can finish, please, is replete with evidence that, if taken in the light most favorable to the plaintiff, would cry out for the need for further examination of the facts. If the appeals court's not going to accept the investigator, then something else has got to come in.
Your Honor, what the appeals board relied upon was the fact that the respondent left a trash can by the bed for her to vomit after he left. She is found naked but for her shoes, alone, covered in vomit. The vomit smells...
But they also relied upon 2 sorority sisters, who they call 2 witnesses in contrast to when they're describing his witnesses. And one of them that they relied upon, who said she was drinking, in the investigative report, she told the investigator she might have been drugged, meaning the witness herself, and that she was not sure. She advised that her memory of the night is iffy.
Your Honor,
So,
those
I
are
mean,
not the key witnesses the appeals board relied on.
I understand that, but let me go back to a fundamental question, which is, the university affords a hearing and an opportunity to cross in every other case. How can they say here, we are not going to allow it?
Because, for 2 reasons. In 2 respects, this process, I submit to you, results in a better development.
Okay, let's say I disagree with that.
But I haven't even told you why.
I know, so why don't you start with answering my question?
I am, Your Honor. I'm trying to explain to you why the process used here, which the university in its judgment believed more appropriate in cases of sexual assault, results in a more detailed development of the record than under the statement. Under the statement, both parties, the complaining party and the respondent, have to show up with their own witnesses. There's no independent ability to do that. So you show up with whoever witnesses you can bring. Second, there is no advanced testimony. And so what you
Would
hear...
you say this is sufficient in a criminal trial?
No, but in the
Okay.
case in this court has always made it clear, you don't apply criminal trial standards in discipline.
No, but this in the effect of this is quasi-criminal to the plaintiff like this. And so, look, I'm not saying he didn't do anything wrong. He may have. The point is he's entitled by the Constitution of the United States to a hearing and an opportunity to cross. And what you're saying is, oh, what we give him is better, yet in every other case that doesn't involve this sexual misconduct, you give a hearing and an opportunity to cross. But you say this is better, then why not do it in every other case?
Because the university, in its judgment, which the courts, the Supreme Court and this court have always recognized, has discretion to identify what are the best procedures. In these kinds of cases, there have been historical underreporting. To have the same kind of in-person confrontation has disadvantages. And so instead, there is a trained investigator who in this case developed a record that I submit to you is more thorough than in any traditional hearing type record would be.
The trained investigator who interviewed every one of these people said he should not be sanctioned.
I know, but this, so the decision of OIE could have been after a traditional hearing, as Judge Gibbons references, the same 35-page report, and it can be reviewed on appeal. And this court also reviews summary judgment determinations on appeal and can make an assessment that when the issue is objective, incapacitation is an objective standard. It's not what he should have known.
What
So the witnesses at
qualifications
the board-
in this particular appeals board, we have a lot of training to figure out what the summary judgment standard is and how to apply it. I doubt this appeals board is similarly trained.
I agree with you, Your Honor, but this is within the university's judgment and expertise. And again, the standard is what he should have known and what the appeals board relied on, not the sorority sisters, not the fraternity brothers, but 3 individuals who had no connection to either party, who saw the complainant minutes after this incident, and she is slurring her speech, she is obviously drunk, she's covered in vomit, she's naked but for her shoes, left alone, and left with a trash can by the bed so she could vomit. And the appeals board makes the decision that based on that evidence, there was sufficient evidence of incapacitation that she could not reasonably give consent to sexual intercourse, and that is sufficient.
And
this
why-
court should not second guess that evaluation.
We're not second guessing the evaluation, we're second guessing the procedures provided to the plaintiff before you deprive him of his rights. And what our problem is we view the due process clause and what happens all the time, and we talked about it in Cincinnati, Doe v. Cincinnati, where we said how fundamental cross-examination is when credibility is at issue. And what you're saying is, trust us, not the Constitution, and let the university tell you what's sufficient.
I'm saying look at Cincinnati and Newsom together. Newsom directly recognizes that cross-examination may not be required, is not required, where the adjudicator does meet with the witnesses as the OIE adjudicator did here. And I agree, that decision maker, Your Honor, ruled against the university, against the complainant.
So here's what you can set up. Michigan can set up a kangaroo court where they have an investigator do this, and they say, look, we gave all the process that's due. And then they can have an appellate panel sanction students all the time. They can do it in race cases, they can do it in drug cases, they can do it in misconduct cases. And you're saying you're going to come to court and say, trust us, judges, because we give them more, because we give them this below, where none of them were found responsible, and then we reverse it and kick them out anyway.
No, Your Honor. The whole focus of this case below wasn't on process, wasn't on procedures, wasn't on the adjudication, it was on the appeals court process. And Judge Lawson took 70 pages of his opinion to evaluate what the appeals board did on an appeal to make sure that that process comported with Doe's rights. And the judge reviewed the evidence, including the sorority sisters that you referenced and the allegations made upon that, to make sure that given the fact that the initial adjudicatory process had been favorable to Doe and then was reversed, and there's no due process violation in having an appeal, but that appeal must operate in a way that doesn't take away the due process that was provided. Doe was satisfied with the due process that was provided in the first phase, not because nothing was taken away from him. There was nothing he identified that was missing from that report. He extolled that report. He said it was compiled.
That's my point. There was no deprivation. So what the university could effectively do is allow a thorough investigation and then have an appeals board where you have no rights to contest credibility, reverse the finding, and expel students.
Correct. So you have to look, just like Judge Lawson did, look at that appeals board decision. It's in the record. Look at the basis for it. Look at the evidence. Judge Lawson did this at great length in his opinion. He didn't just rubber stamp the appeals
I
board.
have the greatest respect for Judge Lawson. I think he does a wonderful, thorough job. Truthfully, but I can't get past the university's indifference, defiance, or whatever you want to call it, to our circuit precedent and to the basic principles of due process.
I urge you to look again at Newsom as this circuit's precedent, where the exact argument was made of a right to cross-examine the complainants who were not identified, and this court said it was not necessary and would impose too great a cost. And a separate issue to cross-examine.
In Newsom, he admitted to the critical facts.
Not in Newsom, Your Honor, absolutely not. Newsom was a case where a high school student was charged with a drug offense, selling drugs on campus.
Oh, that was the high school, that was a high school situation.
It was a high school case, but the issue was expulsion based on selling drugs. And the student absolutely denied the offense. And there were both other students who had provided the evidence that he had sold drugs. And then there was an investigation that was done by a principal, a university adjudicator. And there were separate claims of a right to cross-examine the complainants who had provided the information and the adjudicator. And this court held both of those were not required. And it relied heavily on the fact that the university adjudicator had met with the students, and it said in those circumstances, cross-examination also may just be redundant of what the adjudicator already knew. Here, hearing officer Klein met with the complainant, the respondent, 23 other witnesses, reviewed documents, assembled all of that into a comprehensive decision, just as if there had been a full hearing, issued a 5-page decision.
And we said in Doe v. Cincinnati that accused students must have the right to cross-examine adverse witnesses in the most serious cases. We alluded to what the most serious cases might entail implying. If a case resolves itself into a problem of credibility, cross-examination of witnesses is essential to a fair hearing.
I agree with that. This case did not resolve into a question of credibility.
Okay, so if we disagree, you lose.
I agree. But
Okay.
that case was a he said, she said, no other witnesses. This case was
Your
based
time is
on
up.
incapacitation.
Is there anything further?
Thank you very much. I apologize for going late.
Members of the panel, there we have the University of Michigan's position. You were literally just told that the university has made a concerted decision that it's more appropriate in sexual assault cases for them to have a different process. That is clearly tilting the playing field. There is no legal reason. There is no due process reason. Provide when the stakes are this high.
Can I ask you a question I should have asked you earlier?
Sure.
Which is, what's your best evidence in your Title IX claim?
Yes. Okay, the Title IX claim is based largely on this court's opinion in Miami, but I do want to say this, that
But that he was treated different because he was a male. What's the best evidence of that?
well, honestly, the best evidence is the appeals panel's report. I mean, if you have ever seen a document where the male's version literally does not appear once, it is that document. The female sorority sisters' testimony or statements, verbal statements over the phone are adopted in toto. The fraternity statements are rejected. That
Well, what they said there is the fraternity brothers had a limited opportunity to observe, and they contrasted that with witness 2.
That's not really so, Judge. Witness 2 and witness 1 were together at the exact same moment that the complainant made herself when they turned on the light from the other bed.
Well, witness 1 left, right, and witness 2 stayed. And so I guess my question is, what's to make us think this is because they were male versus because they were members of this fraternity and thus biased? I
Fair
understand
point.
the point.
No, I think that's a fair point, and by itself, no. But when you look at the totality of the opinion, and you see that at every single turn, they talk about, they just gratuitously and falsely say she was not an experienced drinker. I ended up taking her depth. She was a very experienced drinker. They said she had no experience with college parties. I took her deposition. She was experienced with college parties and tailgating.
Well, why is that them just making stuff up versus doing it because
Well,
of
because it
gender?
shows you they're leaning to the female perspective. She's the victim. Nobody cared whether my client had any experience with any of this. It was not remotely of interest to them what my client's experience level was. So there's that. In addition, my second amended complaint, which I was not allowed to file, but was part of the motion to reopen, lays out in great detail the pressure the university was under. I have to tell you that President Mark Schlissel had signed on to a proclamation called Start by Believing with regard to how the university would handle all sexual assault or harassment cases. And it's very clear that the first thing you do is you believe the victim. And I have multiple news articles. They were under investigation by the Department of Education, by the Office of Civil Rights. My second amended complaint lays it out in much more detail than I can do at this time, but when you look at the pressure the university was under, the fact that they were being investigated, the Michigan Daily articles, the student uproar about you're not doing enough, and you couple it with this process, you see my point. But I do want to tell you about the appeal process, because my fellow counsel just stood up here and lauded to you the OIE investigation. But here's the problem he did not deal with. It was swept away by the appeal. And under the Statement of Student Rights and Responsibilities that goes to all other students, members of the panel, guess what? There is an appeal, but the appellate review panel cannot make an independent finding against the accused. It gets sent back. Okay, that's another huge distinction at the University of Michigan, where the field is tilted. And the same thing with the University of Cincinnati, members of the panel. I've looked up their policy. You're familiar with it.
We're veering a little bit, and your time is up.
Okay, I just want to point out that the appeals panel is unique at the University of Michigan. It could sweep away all of the fact-finding we just heard about from Mr. DeBruin. So, Judge Lawson also made credibility.
Look, Ms. Gordon.
Thank you, Judge Gibbons. I hear you.
Okay.
Thank you very much
We
for your time.
appreciate the argument both
Thank
of
you.
you have given, and we'll consider the case here.
Thank you.